Good day everyone, welcome to today's section. Today we are still going to talk about one of the greatest and most famous cases in Great Britain. This case is between Dickinson versus Dodds and it occurred in 1876. It is still on revocation of offer. Now we are going to use the ARAC rule to emphasize or analyze this case. Now we are going to talk about the issue. The issue was that whether an offer could be effectively revoked by the offeror's sales of the property to a third party, communicated to the offeree through a reliable intermediary before the offeree's purported acceptance. What are the rules instigating to this case? The rule was that an offer may be revoked at any time before acceptance, even if the offeror promised to keep it open unless supported by consideration. Revocation need not come directly from the offeror. It is sufficient if the offeree receives reliable notice through a third party that the offeror no longer intends to be bound. Once such notice is received, the offeree knows there is no longer an offer to accept. What are the implications or the applications to this case? Dodds offered to sell property to Dickinson. The offer stated it will be open until Friday. Before Friday, Dickinson learned from a third party buyer that Dodds had sold the property to a third party, Alan. Dickinson still attempted to accept on Friday morning. The court held that Dickinson knew the offer was no longer open. He had learned from Dodds' change of intention through a reliable source. There was therefore no meeting of minds and no contract formed. Now, what are the conclusions to this case? The conclusion is that the offer was effectively revoked by indirect communication via a reliable third party. Dickinson's purported acceptance was too late and created no contract. Thanks for being part of today's section. Don't forget to subscribe. Bye for now.